Hello, I'm Amanda Moore. I'm the director of the Clearinghouse community. Welcome to the Advocacy Exchange for December 2018. The Advocacy Exchange is our monthly conversation with advocates advancing change. Now, both the Advocacy Exchange and the Clearinghouse community are brought to you by the Sargent Shriver National Center on Poverty Law, a national leader in advancing justice and opportunity. Today, I am joined by the self-styled Federal Access Group, as I have been for the past 3 Decembers. I'm so happy that they're back. They have now written 26 annual recaps of Supreme Court terms to highlight the implications for our clients' access to the federal courts. So allow me to introduce them to you in turn. First is Gary Smith. Gary is the Executive Director of Legal Services of Northern California, and he joins us today from Sacramento. Hi, Gary.
Hello.
Also joining us from Sacramento is Mona Tawatao. Mona is a senior litigator at the Western Center on Law and Poverty. Hi, Mona.
Hi everyone.
And finally, we're joined by Jane Perkins. Jane is the legal director of the National Health Law Program. She's joining us today not from her usual place in North Carolina, but from across the pond in London, England. Hello, Jane.
Hello, Amanda. Hi, everybody.
Jane, Mona, and Gary are the authors of this month's Clearinghouse article. It's called The U.S. Supreme Court's 2017-18 Term, A Taste of the New Normal. It can be found on the Clearinghouse community, which is at povertylaw.org/clearinghouse. And I'm eager to talk with them about what happened in the court in the past year. But first, let me tell you how you can be part of the conversation. I know that most of you are watching this on the Shriver Center's YouTube channel, and you'll notice there's a place there to the right for a live chat. You can go ahead and try that out now. You can send us your name and where you're watching. And while we're talking, go ahead and feel free to send in your questions or comments for our panel. I see that Dorinda has already said hello. She is watching in Minneapolis. Thanks for joining. If you don't think live chat is really your thing, that is okay. You can also email me while we're talking. My email address is amandamoore, M-O-O-R-E, at povertylaw.org. So let us hear from you. Everyone who registered for today's webcast will receive a follow-up email in the next few days. It will have a link to the recording of today's conversation, as well as a link to Jane, Gary, and Mona's article. So keep an eye out for that. Well, let's get started. Your article notes a couple of trends in the court, and both of them have to do with this resistance to looking outside the language of a statute for its meaning, even if the statute is ambiguous or unclear. One of those is a strain of resistance to looking at legislative history, and the other is a growing skepticism of Chevron deference to an agency interpretation of an ambiguous statute. So I want to talk about those two trends. Let's start with Chevron. In the article, you note that several opinions have questioned Chevron deference. That's been around, it's been formally in place since Chevron was decided in 1984. So Jane, I'll turn to you. What is going on here with Chevron?
Well, a lot, and it could be happening even this term. Just very quickly to just state Chevron quickly for you. It is, as Amanda said, it's the 1984 Supreme Court case, Chevron versus National Council, that says in step 1, the statute's clear on its face. That's the end of the matter. The court applies the statute as it's written. But if there is an ambiguity in the statute or a gap to fill, then under step 2 of Chevron, the court should defer to a reasonable interpretation of that ambiguity by a federal agency that has been charged with filling the gaps. Under Chevron and cases since Chevron, the level of deference depends on the kind of agency statement. If it's a regulation, for example, it's entitled to deference as a law. It is a rule of law. There's Skidmore deference, which says that you should defer to an agency statement, giving it the deference it is due, depending on the indicia of recent decision making, or statements less than regulations. And then there's our deference, which says that courts are to defer to the agency's reasonable interpretations of its own statutes. Justice Scalia had expressed concerns about Chevron deference in a couple of his opinions, but those statements were kind of hanging out there. Last term, during the 2016-2017 term, I looked back, I don't think the Supreme Court cited Chevron deference in any of its rulings. So something was kind of happening at that point. This term, that whatever was simmering there really broke through. Led by Justice Gorsuch, the court is openly questioning the 34-year-old precedent set forth in Chevron. And there are three cases. SAS Institute Incorporated versus Iancu involved a process for challenging a competitor's already issued patent. And the statutory construction discussion is dense in patentania. So we're not going to go into that, but where it's interesting and relevant to us is when Justice Gorsuch, writing for the 5-member majority, turns to Chevron. SAS Institute had asked the court to use the case as an opportunity to abandon Chevron. Justice Gorsuch said that we're not going to do that because even under Chevron, the statute is clear and we don't need to give deference to what the agency was saying. But he could have stopped there, but instead he sent up smoke signals by quoting a decision from Justice Friendly in the Second Circuit, who argued that there's an impressive body of law sanctioning free substitution of judicial or administrative judgment when the question involves the meaning of a statute, because the meaning of a statute is properly a matter for judicial rather than administrative judgment. After SAS Institute, the court decided Epic Systems Corporation versus Lewis. This is the case that where employees had filed a class action suit to get overtime wages. And if you want to read a very, I think, kind of off the wall statutory construction, looking at the meaning and rationalizing the meaning of two different statutes, read this case. The majority, again, 5-member majority with Justice Gorsuch writing, ruled for the employer, finding that under the Federal Arbitration Act, the employer's requirement that employees resolve disputes through individual arbitration as opposed to concerted activity through class action litigation triumphed over the provisions of the National Labor Relations Act that authorized concerted activity. Again, the court could have stopped there, but instead, Justice Gorsuch left off where he had been in SAS Institute, and again noted that in the case, just out of the blue, he said, no party has asked us to reconsider Chevron deference here, but even if they had, we wouldn't have had to do that because we are more than up to the job of resolving differences in statutes. And the final statute was Perea versus Sessions. In this case, the court refused to apply Chevron deference in a case that involved a notice that was used by the Department of Homeland Security to inform non-citizens of removal proceedings. And the court very easily held that Mr. Perea had not been given a notice to appear as required by the statute because on its face, the statute didn't inform individuals of the time and place of the hearing as the statute was required to do. It's an 8-1 decision with Justice Sotomayor writing. The court said it didn't need to defer under Chevron because the statute was clear. What's interesting here is that in one of his last pronouncements, Justice Kennedy wrote a separate concurring opinion cautioning lower courts against reflexive deference to agency interpretation, particularly where that interpretation concerns the agency's own authority, and stating that it is necessary and appropriate to reconsider the case. Justice Alito, the lone dissenter, while arguing for straightforward Chevron application, acknowledged that Chevron's in trouble, and he described it as an important frequently invoked, once celebrated, and now increasingly maligned precedent. So where does that leave us? Clearly, a majority of the court is giving Chevron deference the snake eye. The court can avoid taking up this question of abandoning Chevron deference by simply doing as it did in these cases, finding that under step one, the statute's clear and it doesn't need to go forward. But as of yesterday, we see the court is going to do more in that they took up granted cert in a case called Kaiser versus Wilkie, and they're going to be looking at the question of whether the Supreme Court should overrule our deference, our versus Robinson, the 1997 case that said courts are to defer to an agency's interpretation of its own statutes. So that's where this all sits. I will just close by pointing out the obvious factor here, which is that how people feel about Chevron deference depends upon which administration's agencies are being interpreted and are under the microscope at the Supreme Court. So these rulings will work both ways over time.
Thank you so much, Jane. I want to say hello to a couple other people who have told us they're watching, Jennifer in Arkansas and Dan in Hawaii. So thank you for getting up so early, Dan. I appreciate you joining us. Well, let's turn now to how the court feels about interpreting unclear statutory language by looking at legislative history. The conservative justices really seem to be digging in even more on their resistance to looking at legislative history. Gary, why is that, and what's the implication of their doing this?
Well, I think it's related to what Jane's talking about with respect to Chevron deference. There has been Justice Scalia, who began the skepticism towards Chevron decades ago. At the same time, he decided that he would not rely on legislative history to interpret statutory disputes, even though that is a centuries-old canon of statutory construction. And he induced Justice Thomas to ride along with that view. And now Justices Thomas, Alito, and Gorsuch will not consider legislative history. Now, one of the reasons that Scalia adopted that view really had to do with legislation that came out of Democratic Congresses during the Reagan administration, which later got up to the Supreme Court. And this is true, like Jane said, it sort of depends on which entity, when you're looking at a political result, enacted whatever the rule is that's at issue. But the Democrats couldn't get important legislation through that President Reagan would sign. So they settled on getting less specific legislation in the areas of environmental protection and civil rights, but they would load up the legislative record with all sorts of statements that were not politically possible for them to get into the actual statute, but which they hoped would aid later if the statutory meaning was disputed. Senator Kennedy was famous for reading into the record all kinds of really specific stuff that he claimed the statute incorporated, which he was not able to get into the statute itself. So Scalia decided that legislative history was not something that he was going to rely on, and he now has, apparently, from the three cases that we looked at where this debate went on, he has persuaded Justices Alito and Gorsuch to go along with him. And now that the majority, the liberal bloc of the court still is believes that legislative history is a legitimate aid to statutory interpretation. But there were three cases in which they jousted back and forth. Even when they unanimously agreed on the meaning of a provision, they still jibed at each other over whether or not legislative history should be considered. So this is a trend that will continue. But again, like Jane said, politically, it sort of goes back and forth. At some point, there will be conservative enacted legislation that the left wing of the court may not want to consider the legislative record in terms of the result. I think that all of this is, part of the conservative movement towards only looking at the plain meaning of the statute, either in the context of Chevron or just in statutory disputes, is a little disingenuous. If parties have spent $1 billion debating and disagreeing over the meaning of a law up to the Supreme Court of the United States, it seems to me that law is probably not all that clear. So there becomes a point at which some speculation about what the real intent is with respect to the specific issue that's being disagreed upon has to come out in the opinions.
Thank you, Gary. I think that we have lost Mona momentarily. I think she'll be joining us again. So, Jane, I want to turn back to you then. Let's look at INRI United States, which was a case about DACA, the Deferred Action for Childhood Arrivals Immigration Program. Let's look at it not so much for the substance, but really for the administrative procedure, and specifically the interplay between accessing the administrative record and the government's motion to dismiss. So, Jane, what is going on here, and why is it important?
Yeah, so after, in this case, after the Department of Homeland Security issued its decision to rescind DACA, plaintiffs sued, and because they were, it was a case involving the federal agency, it was filed under the Administrative Procedure Act. When the administrative record, and these cases are kind of like appeal cases in a way, because they're based on an administrative record. And when the administrative record arrived, the plaintiff said it's incomplete. They made a motion to the district court to order the federal government to supplement the record. Meanwhile, the federal government made a motion to dismiss, arguing that the decision to terminate DACA was committed to agency discretion and thus not reviewable by a court. The district court ordered the record to be supplemented. The federal government took this order to the Ninth Circuit, which refused to disturb the order. It goes back to the district court, and the federal government then moves the court to stay the supplementation order pending its ruling on the motion to dismiss. This gets to the Ninth Circuit. And the Ninth Circuit vacated the order requiring supplementation of the record because it reasoned that if the government won its motion to dismiss, there would be no need for the lower court to examine an administrative record. And I think there's obvious facial appeal to that conclusion. It seems to make some rational sense. And it is a case that is really looking at what happened there in this DACA termination and administrative record. But this situation needs to really be watched closely. For those of you who do federal cases under the APA, you know that the administrative record is critical in an APA case, and any delay in getting a complete record can really place plaintiffs and plaintiffs' counsel at a severe disadvantage. Also, you know that one thing that the United States almost always does in cases where it has been sued, cases like this where it has been sued, is to file a motion to dismiss. This administration in particular has been filing motions arguing that its authority is not reviewable by courts. In a case that we have challenging Kentucky, the Secretary of Health and Human Services approval of work requirements as a condition of Medicaid eligibility in Kentucky, the federal government made a motion to dismiss our case, arguing that the court couldn't hear it, that it was the decision to allow this work requirement was committed to agency discretion and thus not reviewable by a court. That is an incredibly difficult argument to win. The circumstances under which unreviewability are granted are very narrow. However, it doesn't stop the government from making that type or any other type of motion to dismiss. And if this kind of ruling is going to keep plaintiffs from getting the administrative record, that could really hamper their ability to fully and aggressively brief the issues in the case.
Thank you, Jane. I'm hearing an echo. I'll keep going. Hopefully you all aren't. So let's go back to statutory construction, which means going back to you, Gary. There's another case that turned on statutory construction last term, and it now seems a bit prescient, as it was examining whether there's a limit on how long someone can be held in immigration detention without being granted a hearing. So Gary, can you tell us about Jennings v. Rodriguez?
Well, Jennings, it's kind of ironic. It arose during the Obama administration and was litigated for the most part throughout the Obama litigation until it got to Supreme Court. But Jennings was at issue were different provisions of the Immigration and Nationality Act, where two different groups of aliens, as the act refers to them, were being detained, people who were detained upon entry into the United States that did not have a lawful basis for admission, but claimed asylum, and so were detained pending resolution of their asylum claim. And then the second group were people who had already gained entry into the United States and then were detained because something happened that put into question their ability to remain lawfully in the United States, like they were convicted of a crime or something. So both of those different provisions, they authorized the Attorney General to parole, in the terms of the statute, with respect to the first group, parole people for, quote, urgent humanitarian reasons, or parole or release detainees under the second group of folks for no particular reason, but it just had a kind of a catch-all provision. So two different classes of those detainees sued and said, you must be entitled to a periodic release hearing, a bail hearing, essentially. And they relied on a 2001 Supreme Court case that interpreted yet a different provision of the immigration law that implied a 6-month limitation on how long someone could be held in one of these categories before basically a bail hearing would be required. And they did that under a doctrine called constitutional avoidance, by interpreting the statute to imply a bail hearing. They wouldn't have to reach the due process claims that constitutionally would require arguably a bail hearing. So in the Supreme Court, the court in a 5-3 decision, because Justice Kagan recused herself because she probably had something to do with the case during the Obama administration. They rejected the Ninth Circuit's ruling that the statute should impliedly have a 6-month limitation on holding folks before they could get a release hearing, and said that there's nothing in the statute that would allow that kind of an implication. They sort of distinguished the prior Supreme Court case that, on what looked like to be very similar facts and law, did imply that 6-month detention hearing, and then remanded the case back to the Ninth Circuit for to look at the due process claims. So that sounds like a very familiar substantive issue, given all of the litigation around this administration's interpretation of immigration issues.
Thank you, Gary. Let's turn now to mootness, and specifically to the case of United States versus Sanchez Gomez. So that was a challenge to the practice of placing full restraints on a broad swath of defendants. Jane, what was the mootness problem in this case, and how did the court resolve it?
Okay, so in this case, United States versus Sanchez Gomez, Mr. Sanchez Gomez and 3 other individual prisoners challenged the restraint policies that Amanda just described as violating the Fifth Amendment. Before the court could rule on their case, on their claim, their criminal cases were resolved, and the United States said, okay, this case is moot. The Ninth Circuit disagreed with the United States and held that the case was a, quote, functional class action, quote, because it involved class-like claims and class-like relief. And it looked to the Supreme Court's decisions on mootness involving class actions to cover all cases, to cover and apply the mootness principles in those cases to all cases sufficiently similar to class actions in which, because of the inherently transient nature of the action, the claimant claim or interest is going to expire before the court has a chance to rule on it. The Supreme Court unanimously reversed. And I think it's a good decision to read because Justice Roberts really clearly steps through where this came from and why the court is holding as it does, that there is not a freestanding exception to mootness outside of the class action context. And he just makes 4 points. First of all, he notes the American rule in litigation. That is a general rule that litigation is over and can only be conducted by individual named plaintiffs who are being injured. The Supreme Court has recognized an exception in a case that I think many of us have cited, Sosna versus Iowa, where plaintiffs with live claims obtained class certification, and the court allowed the class to continue after the named plaintiffs' claims were resolved because the certified class has acquired an independent legal status with ongoing interest. The court has recognized what Justice Roberts described as limited exception to Sosna's requirements in a case called Gerstein versus Pugh, also one which I think many of us have cited, where the named plaintiff had live claims when he filed his class action case, but the court had not yet decided the class action motion before the case became moot, or the named plaintiff's claim became moot, because the issues that were at present in the case were going to affect this group of detainees, similarly situated detainees, and the practice would typically end before the court would be able to rule. However, the majority unanimously, the court unanimously says the exceptions stop here. In the presence of allegations that might benefit other similarly situated individuals can't save an individual plaintiff's suit from mootness once their individual claim has gone away, has dissipated.
Thanks, Jane. And I'm glad to see that Mona has joined us again. Unfortunately, we don't have a lot of time left, but Mona, I do want to ask you one question. Are you all hearing that?
Yeah, I mean, in the time left, I think I just want to do a little commercial.
Do a commercial.
for two things for practitioners. One is in the Benesek v. Lamone case, it sets out a really good primer on the preliminary injunction standard, the federal court standard for preliminary injunctions of Winter v. National Resources Defense Council, which is a 2008 case. So you want to know what the standard is, take a look at the Benesek case. It was a voting rights case. The other thing I wanted to mention is just a real practical tip from the Artis v. District of Columbia case. If you file a case in federal court that includes a state law claim, so in other words, you're filing and you're asking the federal court to exercise supplemental jurisdiction over your state claims, what happens is that the statute of limitations on your state claims freezes at that point. And then only after, if the federal court decides, no, we're going to dismiss your state claims, then 30 days after that dismissal, the statute of limitations then again starts to run on your state law claims. So you have that time, and that was the Artis v. DC case. If you want to read more details about that, do that. I apologize for the technical difficulties; they were mine, but wanted to end with that hopefully helpful commercial for our article.
Very helpful. Thank you, Mona. And also want to say hello to David, who joined us from North Carolina. Thank you. So thanks for all of you who tuned in. Thank you to the Gary and Jane and Mona today. I'll remind you, there are so many more cases in the article, along with their citations and more in-depth analysis. So be sure to read Jane, Gary, and Mona's Clearinghouse article, the U.S. Supreme Court's 2017-18 term, A Taste of the New Normal. That again is at povertylaw.org/clearinghouse. I want to remind you of a couple of other resources that the Shriver Center has that may be of use to you. One of those is the Federal Practice Manual for Legal Aid Attorneys. That is found at federalpracticemanual.org. Be sure to check that out. Also, keep your eyes on your inbox again. In the coming weeks, we will be advertising for our next delivery of affirmative litigation training, which will be happening in March and April. So keep an eye out for that. Well, this will wrap things up for the Advocacy Exchange for 2018. Thank you so much for joining us, and I wish you, and so does everyone else at the Shriver Center, a very bright and shiny new year. Thanks so much. Bye.
Bye.